All right. Welcome everybody to the IDC CLE on Immigration Collateral Consequences of Convictions. We're so pleased to have you with us today. And we are going to be using Q&A today for you to present questions to our presenters. You can type them in using the Q&A, or if you want to raise your hand, I can then unmute you and you're able to talk and interact with the presenters as well. So those are the two options. The chat feature has been disabled, so you won't be able to use that. This will be an hour and a half presentation since we have so much great information to share with you, and we thought that it would be beneficial to have a little bit more extra time, especially for questions and any discussion that you may have. And I'm pleased to introduce our presenters today. They are Linh, Tran-Layton, and Carlos Navarro. Linh is a managing partner with the JLJ Law Group. She earned her law degree from the University of Utah and has been practicing immigration law since 2009. She has assisted a broad range of clients, from individuals to families who are seeking the American dream, to businesses that are looking for qualified workers to fill the hard-to-fill positions. Linh is also an immigrant and immigrated from Vietnam when she was a 1-year-old, and she has lived in Utah since then. And we're so glad to have her join us as a presenter and educate us about immigration basics and about the benefits of immigration. Carlos Navarro earned his bachelor's from the University of California, Irvine, with a major in criminology, law, and society, and a minor in political science. She earned his law degree from the University of Utah and has been practicing law since 2013. He specializes in criminal defense and immigration law, specifically in the areas of deportation defense and mitigation of criminal conviction collateral consequences. And he is an associate with Stowell Craig since April of 2018. So we are so happy to have Linh and Carlos with us today, and I turn the time over to them without further ado. Thank you so much.
Thanks so much, Katrina, for setting this up. So I will be just talking about immigration basics, a very general overview, so that people have some context when they're speaking to potential clients or clients where some of these issues may arise. So we'll start off with the categories of legal statuses in the US. So obviously there's US citizens, lawful permanent residents, or LPRs, or green card holders, and I'll use those terms interchangeably, but they mean the same thing. And then we have non-immigrant visitors, asylees and refugees, and then undocumented immigrants. So starting with US citizens, so they're either born in the US or they're naturalized. So naturalization is when a green card holder applies for citizenship, meets all the requirements, and then becomes a US citizen. Now, there are some people who are born outside of the US, but they derive citizenship. So an example of that would be like, let's say there's a couple, they were born in the US, lived in the US for most of their adult life. They decide, they get married, and then they decide to move to Italy, and they have a child there. Now that child would likely be able to derive US citizenship from the parents. But other than that, for the most part, people have to be green card holders first before they're eligible to apply for citizenship. Sometimes I'll have people that come in and let's say they came in on a tourist visa and they say, I want to apply for citizenship. Well, it doesn't work that way. They have to get the green card first. For the most part, naturalized citizens can't be deported or removed from the US. I say that generally speaking, there are some rare circumstances where they could be denaturalized, but just for this purpose, I'm just going to say for the most part, they can't be removed from the US. But if they're convicted of certain types of crimes, it could affect their ability to petition for certain family members. And this goes for US born citizens as well. So an example of that would be, I'm sure many of you have heard of the Adam Walsh Act. So part of that act prevents US citizens and green card holders from petitioning for certain close family members if they've been convicted of specified offenses against a minor. So crimes would include like kidnapping, false imprisonment, and sex offenses. Now, it's really hard to overcome this issue if somebody is subject to this, a citizen is subjected to this. And I'll give you an example of that. So several years ago, I met with this man who was a citizen by birth, and he petitioned for his parents to get their green cards. Ultimately, the petition got denied because of the fact that he was a registered sex offender. Now, what caused that is, so when he was an older teenager, he got into a relationship with a girl, and I think she was 14 or 15 at the time, and he was 2 or 3 years older than her, so not a huge age difference. But anyway, she ended up getting pregnant, and then she went and had the baby. They found out how old he was, and he got charged with statutory rape and convicted. And so he ended up being a sex offender. He had to register as a sex offender, and his petition for his parents was denied. And one of the things that they look at is, what's the risk that the petitioner poses to the family member that they want to petition for? I think for the most part, we could say that he probably poses no risk to his parents, but for whatever reason, the petition was denied. So like I said, it can be overcome, but it's very difficult. Now, in the cases of where citizens are petitioning for fiancés, criminal history does generally have to be revealed to immigration. So I'm sure some of you have heard of the 90-Day Fiancé show. I have, but I've actually never watched it. But in those cases, so this screenshot is of the questions that are actually on the fiancé petition form. Now, only US citizens can petition for fiancés, but if you see here, you'll see the questions that are asked. Again, the Adam Walsh Act comes into play in these scenarios as well. And in one instance, I had a client who he was thinking about doing the fiancé petition, but he had some lewdness convictions. And I said, well, I think you're better off going the spouse route to avoid any issues. And that's what we did. And ultimately it got approved, the spouse petition, and she's here. But with the fiancé petition, at the interview, when the fiancé goes to the interview, the officer will reveal all of this criminal information to the fiancé. So basically, they know what they're getting themselves into, and basically to protect the fiancé from being subjected to abuse, potentially. All right, so the next category is lawful permanent residents. So these are, again, like I said, LPRs, green card holders. They can live permanently in the US, they can work, they can travel outside the US. They are eligible to naturalize after a few years, so it's 3 or 5. And that's dependent on how they got their green card. So if a person got the green card based on marriage to a US citizen and they remain married, they're still married, at the 3-year mark, they're able to apply for resident or citizenship. Otherwise, it's 5 years. Now, a green card holder can lose their status by abandonment or for committing certain types of crimes. So when I say abandonment, it just means that where the green card holder has left the US and they're gone for too long of a period of time. So usually a year or more can bring into question whether or not they've abandoned their residency, because they're supposed to be living in the US permanently. And then of course, they can lose it by committing certain types of crimes, and certain types of crimes can also bar somebody from ever being able to apply for citizenship. All right, next category is non-immigrant visitors. So these are people who have a visa to legally enter the US. It allows them to stay for a temporary period of time. How long they can stay and what they can do while they're here depends on the type of visa that they have. So I'm sure a lot of you have probably come across people who have F1 student visas or B2 tourist visas or H1B temporary work visas, and there's a ton of other different types of visas as well. Now, some of them do end up overstaying. That happens pretty often. The next group is asylees or refugees. And these are people who have a well-founded fear of persecution based on race, religion, nationality, political opinion, or membership in a particular social group. And the difference between a refugee and asylee is basically where they apply for the benefit. So a refugee applies for refugee status outside of the US, and then they can enter in as a refugee. Asylees are people who either apply like at the port of entry, like let's say they come to the US, let's say US-Mexico border, and they go to a customs officer and they're saying that they're afraid to go back to their home country, or they could already be in the US and they apply for this. Once a person has been in asylee or refugee status for a year, they're eligible to apply for a green card. Now, I have had some clients who have had this status, and while they've had this status, they've committed crimes. And then now they're wanting to apply for their green card. So for the most part, there is more leniency that are given to asylees and refugees who have a criminal history versus other people. And obviously the reason is because if they were deported, they would have, where would they go, right? Because they can't go back to their home country. But ultimately it's still discretionary for this waiver. So there, obviously criminal history still matters. Sorry, I have a little bit of a cold. So anyway, so yeah, so again, criminal history matters, and I think that's kind of the theme in all of this is regardless of what status the person has, their criminal history will matter if they're going to be dealing with anything immigration related. All right, so then the last group I'm going to talk about is undocumented immigrants. So these are people who have entered the US without any type of legal documents. They were not inspected by an officer. They have no legal status here. And it's not somebody who has entered legally with a visa, but has overstayed. Technically, those are two different categories. And then there are ways for an undocumented immigrant to get legal status, but it's not as easy as some people may think. A lot of times I hear people say, oh, well, why don't they just get in line and apply for citizenship? I mean, really any immigrant, and it doesn't work that way. It's not as simple as that. And there may not even be a line. And for some people, the line could be a 22-year wait, 19-year wait. So, you know, immigration laws and procedures are pretty complex, as with really any area of law. But that's my portion. So hopefully that gives you some context as we move forward. And then I'm going to turn it over to Carlos.
Does anybody have any questions that you would like to present to Linh before Carlos takes over? You're welcome to use the Q&A question or raise your hand. And you can, of course, enter questions at any point, even for Linh, while Carlos is presenting. So feel free to do that. And they both definitely would welcome your questions. So take advantage of that while you can.
Yes, definitely.
Carlos?
I'm happy to answer any questions.
Hi, thank you. Pleasure to be here. I'm actually more nervous doing it this way for some reason than in person. But let me see if I can share my screen here. Can you unshare your screen, Linh?
And Linh, while you're doing it, there is one question from David Shapiro who asks, how does DACA relate to these categories?
So that's a good question. So DACA is considered deferred action. I mean, I guess in some ways that gives it gives the person the ability to continue to stay in the US and not be removed or deported from the US. So again, DACA is also, when somebody or their criminal history is always going to be relevant as well. And I don't know if Carlos will get into that. I know Carlos has a lot to cover. But yeah, so I mean, like I said, with anybody who is anybody really with any status, there's always some sort of potential immigration consequence for criminal convictions that they may have.
So Linh, somebody just asked, is DACA related to student visas or any other of the statuses?
No, it's not. It's a totally separate thing. Now with DACA, for example, an undocumented immigrant could apply for DACA, or if somebody entered with a tourist visa and they've overstayed, they've never left, that person could be eligible for DACA as well.
Okay. So My name is Carlos Navarro. Linh, can you confirm that you can, sorry, I see my screen here, the presentation?
Yes, I can see
Okay.
it.
Sorry for that. So this kind of presentation, I've done it before, but it is a little bit nerve-wracking because this is so nebulous. This whole area, trying to tell you about immigration consequences is something like being able to do math in your head, but then having to go and explain to people on a whiteboard how to do it. And then also the numbers can change at any time, and there's variables, and then people come in and erase the whiteboard when you're gone. So I'm trying to narrow this down to three basic topics, three basic questions: the why, the what, and the how. So why are immigration consequences and outcomes so difficult for us to predict? Why do we hem and haw sometimes? Why can't we just give you a straight answer? Why do you even need us? Why can't you just figure this out through memory with the clients you've already helped before and how things have gone for them? So the what. So what are the differences between aggravated felonies and CIMTs? Oftentimes, attorneys call me and they just want to know, hey, is this an aggravated felony or is this a CIMT? But they don't see the other. They're blind to everything else that's possible, all the other hazards in the room. And then finally, the how. How can immigration consequences be mitigated? And I do say mitigated because it's very tough to make it fully foolproof. Like things can change, new case law can come in. We might get a bad decision or a judge that disagrees with us or an immigration official who doesn't agree with our version of the law, and then we have to spend thousands of dollars litigating it. So this is, I'm gonna attempt to do something I haven't done before. I'm gonna try to get into the weeds a little bit and give you very specific Utah's crime specific assistance and suggestions. I would highly recommend you reach out to me or a member of my firm. I work for Stoll Craik. I'm sure many of you are familiar with Adam Craik already. I know LDA, you usually have sent him emails. If you just check all your emails, he's essentially given a lot of our playbook away over the years. But please don't rely solely on this. I may have misspoken. The law may change. You may have misunderstood. So confer with us. We don't have a problem. We're not gonna, we won't blow you off. Just send us an email, give us a call. We'll help you out. So first, and I'll try not to spend too much on the why, but as I kind of alluded to, immigration law and criminal consequences are constantly in flux. And the reason is, frankly, there's just too many people involved. There's too many cooks. First, it starts off with Congress. Congress wrote these laws, the US Code. And just so you know, US Code is directly parallel to the Immigration and Nationality Act. I'll refer to it as the INA. So unfortunately, it has a different numeration, but and that's a little confusing, but it is the same language in the code. So US Code might be 1102. In the INA, it'll be section 212. And I'm sorry, I'm going to refer to it as INA. I'm just not familiar with US Code. I'm not used to doing that, but hopefully I'll explain to you how to go about finding those differences. Oh, another thing, I'm super open to questions. I want to spend this time talking about stuff that you all want to hear and know about. I don't want to ramble on about stuff you already know from law school. So in addition, so there's US Code. Our laws haven't meaningfully been changed since about 1996. And these are the laws we have currently in place. Immigration law has changed a lot, but not because of Congress. It is mostly changed because of judicial interpretation and agencies' interpretations. You have federal agencies, so USCIS and the DHS, the AG, who help craft the CFRs. The AG, I'll get into that a little later, they craft decisions on how they're going to interpret the law, and that all affects us. Then we have state legislatures who enact our criminal code. Well, you wouldn't think, I mean, we're always trying to fight saying, state law has no business in immigration and they can't do this and, stay out of it. But the simple fact is state legislators make a huge difference in how immigration consequences will play out. Really quick example, for, I believe, the beginning of the state, misdemeanor class A in Utah was 365 days. Well, that was always problematic for us when I started in 2013 because 365 overlaps with the federal definition of a felony, 365 days or more. And so finally, I believe in 2019, the legislature got on that, and miraculously, it was unfathomable when I started. Utah was one of the few, I guess you can say, progressive states to change the definition of a misdemeanor to 364, and that has helped us out tremendously. That's one big thing we no longer have to worry about. And finally, I mean, local municipality city ordinances, honestly, it's not a huge deal, but they do affect it because the language they choose to use in the statute makes a huge difference in how immigration will interpret it. If they throw in there, it's not a strict liability offense, you have to have an intent to do something immoral, like an intent to lie or steal, that can have a big consequence, even if we're talking about a Class C misdemeanor. So I know Linh got into the statuses, but another reason, and aside from the law and the statutes, we also have immigration courts and Article 3 judges who affect our laws. So the first person usually to review this is going to be an immigration judge, and they give us the first decision telling us whether they agree that our client is not deportable or this offense isn't a big deal or not. And I guess even before then, you have the ICE attorneys, that we call them OPLA. I don't even know what that stands for anymore. They recently changed it off of, Linh, do you remember what that stands for? Well, they used to be OCC, Office of Chief Counsel, and now they changed it for some reason. But first, they're like the prosecutors here. They determine if they think they can try to deport somebody. Then after a judge says yes, then we might have a fight about it. In this case, the government or us can appeal a decision. So even if we win, the government can appeal, and it's possible that the BIA, the Board of Immigration Appeals, or even the circuit courts, or even the Supreme Court could side with them that we're wrong. So where I say, hey, burglary in Utah is not a deportable offense, we'll fight about it, and they'll go and look at Utah statute, and then they'll look at how Utah courts interpret it, and they'll let us know. So we can still lose. Unfortunately, unlike criminal law, the government can appeal here and often do. So then district courts, district courts, same thing. They really don't get involved unless there's special jurisdiction. I don't want to get too far into that. I don't want to confuse you, but I'll just cover that in a second, in a few minutes. So Utah courts, they play a huge part, believe it or not, because federal law, as you probably know, will defer to state court interpretations. So how does Utah courts interpret the essential elements of an offense? We're always trying to say, no, you don't need to show which specific substance a person admitted to possessing or selling. It's enough that they are pleading to a controlled substance. So then we've had to fight about that all the way up to the circuit courts and the BIA, and explain to them, well, what does Muji say about that? Does Muji say that a jury must necessarily find which specific substance, or is it enough that they agree that it was a substance on Utah's controlled schedule list? So far, we have not been successful in convincing them that we don't need to identify a specific one as much as we'd like to. So far, they've been pretty adamant that it does require the identity to be unanimously agreed to. And there are Supreme Court cases on that, DACA and several others. Let's see, how am I on time? Okay. 24. Okay, so I don't want to spend too much time on this. So yeah, like as I was saying, DHS has a big part in how this is interpreted. Their attorneys look at this. USCIS officers interpret it. U.S. Attorney General, unfortunately, sometimes they stick their big nose into this, into our matters. They can, if I have a case, if I have a deportation matter in immigration court and I lose and I appeal, the AG can say, hey, BIA, I'm going to take this case and refer it to myself, and I'm going to decide what the law is. So then they get to control, and that has had a huge impact on us, particularly during the Trump years. Well, I'll say negative impact during the Trump years. We had some positive impacts in prior years. But for example, whereas we were able to do 402 reductions, 402 reductions for a long time in Utah, and US immigration would be forced to accept that. AG Barr, I believe, released 2 decisions, Matters of Thomas and Matter of Thompson. And we're still living with those today, where he unilaterally decided that immigration law would not, or immigration authorities would not give any credence to any 402 reduction or any trickery that Carlos might go in there and do years after the fact to reduce, to modify, or quote unquote, to clarify a sentence. So often what we would do is, get a 402 reduction, that's obvious, but we'd have to go in there and clarify, well, a few years back, the attorney in the case said it was marijuana. We'd actually like to clarify it was something else, if you get that kind of stipulation or if you can prove it. You know what, a substance was never identified here, and the parties are okay with this agreement or legal fiction and no harm, no foul. Well, they're no longer going to afford any credence to that unless we can prove there was some kind of constitutional defect. Plea was not known involuntary, rights were not explained, and mostly that's post 2010. So anything prior to 2010, it's a really hard sell to get that to happen. We're still on the why. Why is it so difficult for us to just give you straight answers? These are why. There's so much to keep in your head. It's hard to even diagram this in a way that'll make sense, that won't just look like gibberish or like physics on a whiteboard. So the what are the differences between aggravated felonies and misdemeanors? Well, a really important thing to understand here is that it matters. There's 2 sets of basic laws that apply here. There's grounds of admissibility into the US, people that want to come in physically or legally, and also people that are here physically but are not here legally. They are considered to never have been admitted, so they would be subject to admission bars. That's under INA 212. We're going to get into that. Second, there's people who are already physically and or legally here, usually legally. They are subject to a different set of laws, section INA 212. Well, in addition to these 2, there are many more complications. We may or may not get into those, but we have to keep those in mind. And in order to properly analyze whether a conviction will be detrimental to somebody, you need to understand the background of the person and what their goal will be. What is their situation? So they come into play when, for inadmissibility, for benefits. When you ask the government for something, a visa, an immigrant visa, a non-immigrant visa. And just so you understand, I think Linh covered this, but non-immigrants are people here who are expected to return home at some time. They're here temporarily, visitor, tourist, employment. But then immigrant visas, green cards, even citizenship, they're going to go back and review your entire history. So even if you got away with something for a long time, if they find out about it, they could even try to take away your citizenship even after you get it. And then removal proceedings, that's usually 237, where they try to find out, do they have something that they can remove you for, like legal justification. So we'll get into that a little bit. So now we're into the what again. And that just goes over the 212 and 237. Hopefully that'll help you remember. So the first thing you want to keep in mind is, what is the status of the person that I'm trying to help? If they're your public defense case, you always want to ask, are you a citizen? If they're not, then your red flag should go up. So are they a permanent resident? Do they have a green card? So for short, we call them LPRs, or a lot of people just know them as green card holders. The technical term for the green card is an I-551. You want to ask them, and you want to find out, it's very important you find out how long and they've had a green card and how long they've been in the country. The other type of person is a non-immigrant, so tourist, student, worker. Then refugees, they're kind of in a category all on their own. And then no lawful status. That is a huge amount of the clients that we deal with. EWI, for short, we call them entry without inspection, or sometimes they came in with inspection, but now they overstayed. It's the same thing. They're here unlawfully. So at this point, it's important to point out the criminal stuff is in addition to. Immigration does not need any other reason beside the fact that they're in the United States without authorization to charge them with removability. And they would charge them under INA section 212A6, physically present without admission. So they don't even care at that point if they've been convicted of murder. They're only going to charge them with being deportable without having it sought permission or unlawfully. So then the criminal convictions come into play later. Once you're in court and it's found that they can legally deport you, then the question is, do you have any relief? Well, the laws will tell us whether if a criminal offense will bar you from seeking relief or not. So many times people say, is this going to make my client deportable? Well, the thing is, if they're iwi, they're already deportable. This is just what you're trying to do now is mitigate the damage and avoid detection by immigration. So avoid jail time is usually the number one goal. I'd say number two. The number one goal is to think of long-term consequences for your client. If it's anything drug related, that's going to have a lifetime bar on their status. If it's fraud relating to possessing a U.S. citizen's birth certificate or passport, even if they're fake, that's a permanent bar. There are no waivers for that. So immediately you need to contact one of us, or really look into this before pleading them out, because so what? They're deportable now. Maybe they want to come back in 10 years. Maybe they have a way of coming back. But if you plead them out to some certain things, their long-term life goals will be impacted. So, and I'm hesitant to put up the slide, but I left it in. It's kind of like a nebulous concept. Yes, crimes usually can equal deportation or inadmissibility, but it really does matter where they are, who they are, what relief they have available, and what they can apply for. So there's, like I said, the relevant statutes are 212 and 237, but there are many exceptions that apply. Unfortunately, immigration makes it extremely hard to just go in there and read this and understand and have a very clear understanding. I'll be honest, I don't have all the answers. I still have to research. I still go and look at 212 and 237 every time that I am considering a plea deal, because I cannot remember it. I always remember one word wrong, or one word, or I get them confused, and there are very important differences here. So let's get into this. Let's get into the aggravated felonies, and I'll show you what the differences are. So aggravated felonies, those are a very finite list of offenses. You probably know that. I don't know if you know this, but they can all be found in INA 101-43, murder, aggravated, and I'm sorry, this is an old slide. This is a mistake. I should strike aggravated assault, although I think there might be certain ways to plead to it where it'd be a problem. Certain sex assaults, but not all. Theft offenses. So this is me trying to condense, but I made a mistake here with my slide. So let me bring in, hopefully you can see that. So under INA 101, it actually tells you murder, rape, sexual abuse, illicit trafficking, and controlled substances. Trafficking, not possession, but trafficking. Theft offense or burglary offense for which the term of imprisonment at least 1 year. That is the very important clause here. So if you can ever plead down to an A, that will help tremendously, but that won't get you completely out of the woods, because a theft offense is still a CIMT. And if it's more than a Class B misdemeanor, they will need they will be subject to deportation, or if they're seeking admission or a waiver, they need to seek for a special waiver to get rid of that CIMT. So theft is an example of something that's both an aggravated felony and a theft offense. And again, really quickly, I'm sorry, I hope I don't just jump around and bounce around too much. This is very nebulous stuff, and I've struggled many years to try to explain this in a very neat and orderly way or direct way. But I get that at this point, we have another level of complexity. what Utah considers illicit trafficking of a controlled substance is not necessarily what the federal government considers a controlled substance offense. The government, if they wanted to deport a lawful permanent resident of drug trafficking, they need to prove to an immigration judge that this person violated Utah law and that Utah law is parallel with the federal equivalent, the federal generic equivalent. Well, if we don't list what substance, if it's never determined which substance they were convicted of possessing or trafficking, they might not be able to meet their burden to show they are deportable or inadmissible, or excuse me, deportable. I'm going to keep it to deportable. Remember, inadmissibility is always way different. Because Utah's controlled substance statute contains right now 2 substances that are not on the federal schedule, our schedule is more broad. It's overly broad than the federal equivalent. Now, there's a whole other area of complexity that I can't get into right now about how to determine if the judge or the government can peek into the record of proceeding and determine which drug our client was guilty of pleading guilty to. So even if you scrub, and I always recommend this, try to see if the prosecutor will file an amended information to take the specific drug out of the information, and then in the statement of advance of plea, ask to say if you can plead without mentioning the specific substance. They might try to still peek into the record to see what it was, and there's a whole dogfight about that. But as long as you can try to keep the substance out of the record for LPRs, then you've done your job. Or even better, in my opinion, if you lock in the substance as a non-federally controlled substance, that would be best, because then there's no argument about what it could be. There's no need to peek into any of the record of proceedings or anything like that. You lock it in as, right now that's HU 211, and that's under the subsection 4.2. I think I have that up, and number 27, if I can remember correctly, sorry if I'm not. And then also a substance called phenylfentanyl. Prior to, like 6 months ago, there was a third that we always used, benzofentanyl. There was a BIA case specifically stating that the benzofentanyl and phenylfentanyl were not listed in, I forget which state's controlled substance list. So therefore it was overbroad and they were not federally regulated. And this was not a deportable offense. So we've been clinging to that. About 6 or 7 months ago, the federal government added benzofentanyl to the temporary list, this temporary schedule. I don't know that it's officially been added, but the temporary schedule is enough. We cannot use it anymore. That used to be a safe harbor, but it is no longer. So here's aside from remembering that there's inadmissibility and removability, you also have to remember it's not enough to just say, okay, they're safe from an ag fel, that's it, end of the analysis. No, you got to remember they can get you one of many different ways. So both INA, most of the laws that talk about relief say you need to satisfy both 212 and 237. So it'll say, if you want to cancel your deportation for this person who's undocumented, you must not have a crime listed under, must not be inadmissible under 212, and you must not be deportable under 237. Same thing for bond. In order to be eligible for bond, you must not have one of these 2 offenses, or one of these 2 types of offenses. And so let me just proceed now. I think I've rambled on too long on that one. So a difference between 237 and 212 is how they list specific, or what makes you deportable is slightly different from what makes you inadmissible. So under section 237, a resident or a person can be deportable if they have an aggravated felony. But oddly enough, there is no such thing as an aggravated felony under section 212. Those words do not appear. Instead, they focus only on crimes involving moral turpitude. Now, it's possible for an offense that would ordinarily be an aggravated felony to be the same one that shows up on your CIMT, and that's okay. So there's certain offenses where my client has an aggravated felony and they're screwed. they have a green card, they're gonna lose their green card. So then we have to look, do they have any other option to get a new green card? There's no rule saying you can't get a new green card, even if you've lost one already. But in order to do that, you need a specific way, petitioner. You need an adult son or daughter over 21 or a spouse that can petition for you, and you're gonna need a waiver. And then there's a whole other complicated analysis as to whether you can get that waiver depending on what the conduct was. Drug possession is killer for inadmissibility. A single possession of meth, a single possession of cocaine can make you inadmissible for life, just simple possession. On the other hand, if you're a resident and you've been a resident long enough, simple possession can make you deportable, and you might have to pay the immigration judge a visit if they try to deport you, but it is waivable if you have the time. If you have 7 years physically in the country and 5 years with a resident status, but then you need to show rehabilitation and a bunch of other things. But that's another difference right there. Federal controlled substance offenses are killer for admissibility. They're not necessarily killers for deportation, though you might have to go through deportation proceedings to waive them. CIMTs, that's where they focus. While we're on the topic of drugs, this is another huge kind of catch-all overstep. Under 212, if you have a drug trafficking charge and the government believes they have a reason to believe that you have ever participated or in any way been involved with drug trafficking, they can deny you admission to the United States. They can say, look, you were charged and you worked out some amazing deal, or you did some kind of diversion. We believe, based on these police reports, if you give it to them, that you were involved and therefore you are permanently inadmissible to the United States. That's it. There is no waiver for that. There is no arguing. There is no appeal. They just say, we have a reason to believe, and that's it. You're done. So you got to be really careful with drug trafficking. And if you were to plead your client to trafficking HU 211, that would be optimal, because you lock it in as a drug that's not federally illegal. And yes, they're trafficking, but it might as well be trafficking in baby powder. Technically, you're not inadmissible, but under this reason to believe standard, it's so broad that they can say, look, we're not going to give you your residency. You're asking us for something. You got to prove you're admissible. We're not going to give you this status unless you give us the police report in this case, and we can get a fair look at what happened. Well, the police report says they were trafficking all kinds of cocaine. They're going to pretty much take that as the truth, and they're going to say, they very likely could say, sorry, we know you weren't convicted of cocaine, but it looks to us like you've been involved in trafficking. We have a reason to believe, therefore you're out of luck. No, you're never going to get a green card. So they're both dangerous in their own ways, but there are very important differences to keep in mind. And the thing that took me, sadly to say, years to remember is that, like, oh, good, this is not a CIMT. But then there was this whole other analysis I need to keep in mind of. There's violent and dangerous offenses, things that just make it impossible for your client to get relief. I think I'm going to skip this. Kind of already talked about that. Pleas in abeyance. I wanted to talk about this because this is, and we'll get into the specifics in a while, and hopefully we can get some questions too, specifically, because I want to go through some scenarios, and if you can, maybe write out some scenarios, hypothetically, not real world people, but hypothetical situations of what I would do. And I'm also going to answer a couple of questions that I got ahead of time. So pleas in abeyance. Pleas in abeyance in Utah law are worthless for immigration. They don't do anything. So a conviction under the Immigration Nationality Act is an admission of guilt accompanied by any restraint on liberty. So an admission, you entered a no contest or guilty plea, you admitted, admitting the essential elements of the offense. Then, even though the sentence was suspended, even though the Utah Supreme Court in, I believe it was Mesa Ramos, said there is no imposition of guilt, there is no sentence, they still take it as a punishment that you have to pay a fine or behave on a plea in abeyance period. So avoid doing them. In action, the way I do it is I use plea in abeyances as a bargaining chip, but I flip the tables. The prosecutor wants to offer you a plea in abeyance to a retail theft. Instead, I would flip around and say, you know what, that's not going to help my client because that's still going to be a CIMT on the record. How about I give you a straight plea to wrongful appropriation? And more times than not, that works out. And if they give you some trouble, try to explain that, just advocate for your client as best you can. Just try to say, look, this is the problem and here's the situation. I'm not going to do it again. But honestly, part of what we do is sometimes offering the state or offering our client a worse deal than they're being offered in order to avoid a conviction. Another quick side tangent on this. So child abuse. If your client, whether iwi or resident, has a child abuse conviction, they're going to hurt. So let me show you how that works. And the person is iwi, they have no status. If they are convicted of an intentional or reckless child abuse under, I think it's 2A or B or 2, I'll look at the statute, but the point, I don't want to just get into that weeds. If you take intentional or knowing or reckless, they are gonna, it's gonna really harm them because yes, they're already deportable just for being here. But when they get to removal proceedings, whenever that happens, they're gonna seek relief and they're not gonna be able to because they will have triggered CIMT and a specific subsection of 237 that says child abuse is not okay. It's a specific ground of removability. In order to avoid that, there is 10th Circuit case law out of Denver that said, who has a very similar statute. And they said, if you commit child abuse negligently and the statement in advance of plea or the factual basis is that no actual physical harm resulted, you can avoid the consequence. You can avoid that specific charge of removability. And so that's what we try to do. We try to negotiate to get that factual basis in and that subsection. And there's been times where I had to go up to the felony. It sounds ridiculous. It's stupid. They're charging my client with a B, and instead, like, I can't take that because they're going to be screwed. I will give you a class A or the felony, and I need to go look at that statute to see which one it says. But maybe we'll get into that when I get to that specific case. But I'll show you the subsections so that I avoid doing what I'm doing right now. Diversions are still very helpful. Diversions are the best tool. It's just as you know well as I do, they're very few and far between. It's difficult, but diversions are the best. And if you can get that, there is no admission of guilt, and technically there's no imposition, or arguably there's a restraint on liberty, but it's not imposed by the judge, so it doesn't count. Prior convictions have an illegal case. So when somebody has been deported previously, they are in a really tough situation. All you can really do is just mitigate and keep them out of jail, because if ICE finds them, they can remove them again on the spot. They can put them in federal criminal proceedings and charge them with reentry. So with those type of crimes, I mean, you don't have to try to walk on eggshells. You just need to try to avoid them going to jail. You also have to see what their record is previously. If they already have a crime that makes them permanently inadmissible, drug trafficking, drug possession, some kind of super violent offense, I mean, there's really nothing you can do that's going to make the situation worse. You just got to try to keep them from going to jail and falling in ICE's hands. So yeah, relief from removal, this is where all these kind of ideas come into place. What kind of person are they? What is their kind of status? And then what is the offense? And the relief from removal statutes kind of tells you why you need to look at 212 and 237. So even if your client is removable because they're here illegally, or their residence and the crime they're pleading guilty to makes them deportable, here's the things we can do. If you're able to properly submit a plea in the case where you give us a good argument to fight that it makes them not deportable, we can get the case dismissed. So ICE or OPLA will file the notice to appear. It's the NTA for short, we call it. It's the charging document. They make allegations. They say this person is not a citizen. They were received a green card such and such date. Then subsequently in the state of Utah, they pled guilty to drug trafficking. Therefore, they are removable under 237, blah, blah, blah. Well, we have been successful in this court in Utah, as well as some courts in Colorado, showing that even where somebody has been convicted of drug trafficking, if it's pled to correctly, like very specifically, we can show that they are not deportable. Specifically, Utah's law does not require a monetary remuneration in order to, as part of the essential elements of the offense. That is a departure from the federal equivalent, which does require monetary remuneration. So when you see drug trafficking, always think, can I change the substance? If they say no, can I leave out the substance? Maybe. And even if I can't do either of those things, either way, it'd be great if it still says for no monetary remuneration, offered, provided, shared, whatever you want to say in this factual basis, but no monetary remuneration is key. So the main relief from removal for lawful permanent residents is cancellation of removal. You need to know this because your green card holding clients will need to rely on this. In order to qualify, they need, as I said earlier, 7 years physically present in the country. This 7-year clock stops the day they are convicted of the offense, the day they commit the offense. So if they've only have 4.5 years in the country, and then they go out and commit possession of a control, or they are charged with possession of a controlled substance, their clock will stop that day. If they're ultimately convicted, the immigration authorities will consider the date of the offense the day their clock stopped, and that will never start again. So they will be ineligible to cancel the removal. If it happens after the 7 years, you're golden. So the other part of that is 7 years physically in the country, 5 years with a green card. Luckily, the green card clock never stops. So if they only have 4 years with their green card, but they've been in the country for 10, and this happens all the time. People are here illegally, later get a green card. So they have 7 years physically present, and they only have 4 years with their green card. On the day of the offense, the clock will continue to run. By the time they get to immigration proceedings and their case is determined, they're probably going to have a green card for 6-7 years or maybe more. So but still, our number one goal is to keep them out of removal proceedings because it's extremely expensive. If it can't be helped, we at least make it so that we have very confidence that they will be able to get relief. For our EWI clients, entry without inspection, no status at all, this technically could include DACA as well, because they're kind of shielded. It's kind of like a promise to leave them alone, but if they commit a crime, they're not going to leave them alone. They're going to cancel that promise. So cancellation of removal for non-permanent residents. This is a special cancellation where they need to show they've been in the country 10 years and they have a qualifying son or daughter under 21 or a spouse or parents that are residents or citizens. They have to be, we call them qualifying relative. It has to be a citizen or a resident, and it has to be one of those 3 people. If they don't have one of those 3 people in their lives, they're not going to qualify for cancellation anyway. So you're only looking at long-term goals. I don't want to screw them for life, or I don't want them to be done for life. So I'm still going to try to avoid this drug conviction. Just because they don't have immediate relief right now or in the next couple of years doesn't mean you give up and plead them out to something crazy that's going to harm them for the rest of their life, because many of them still do want to come back someday. And just as I guess I should mention, 212 and 237 are all over these reliefs. In order to qualify for cancellation of removal for non-LPRs, you can't have an offense under 212 or 237 with some exceptions, and it's more complex. I'm not going to get into it. So adjustment of status. If your person does not have any status at all, and you still got to try to make sure they might be eligible for adjustment of status. What that means is they came legally into the country. If they entered legally, if they have a legal admission physically into the country, then they will have the benefit of getting a green card in the United States if the appropriate relative can petition for them. However, they're going to be subject to Section 212. So if they have any offenses that trigger the criminal elements of 212, they're going to look very closely at that, and you might need to require a waiver. For people that you suspect or could maybe be seeking a green card someday, well, regardless, for anybody that could be seeking a green card, try to avoid violent or dangerous offenses. Plead to anything that is not a violent or dangerous offense and not drug related. The reason is there is a waiver for CIMTs, but there's a special kind of dagger there that says, however, if the offense you need a waiver for is a violent or dangerous offense, you must show exceptional and extremely unusual hardship. That is almost impossible to do. And it counts. If one of the grounds of inadmissibility is if you have 2 or more offenses, it doesn't matter what they are, just 2 or more offenses, that the total potential jail sentence was 5 years or more. So if you have 1 felony DUI, or it's really, well, I guess you could do that. So if you have 1 felony on your record and then 1 traffic citation, you are subject to this ground of inadmissibility. So this happens quite a bit, particularly with a lot of my female clients. They have 0 criminal record, but they've been working for years with false documentation or false social security. The state charges them with identity fraud. I am able to convince them to plead out to possession of another's ID in order to sweeten the deal, because it's such a big departure from fraud or possession of a forgery document. Because it's such a big departure, sometimes I have to offer them a felony. So it's a felony if you possess 2 or more identity documents of another. So right there, they're on the bubble, felony. And I have had people who go into removal proceedings with that. I have been successful in getting the government to agree, yes, they do have an offense for which at least it's punishable up to 5 years. However, this doesn't disqualify them from relief until or unless they actually get 1 more offense. A traffic citation could set you over the ledge. So that's just one thing to look out for there. You won't know. We're getting into weeds, but I'm hoping to at least give you some things to think about. Hopefully, when you see a case, it triggers your memory and you remember to reach out to us or somebody that you trust. There's also things like asylum, Convention Against Torture. For asylum and withholding of removal, they have something called particularly serious crimes. This is so wishy-washy and fungible that it's aggravating because there's no actual definition. It is, we know when we see it, if it would qualify as an aggravated felony, it's very fair to say that it would be a particularly serious offense, but this is mostly judge-made law, just so you know. Possession of a firearm, judge-made law. They'll say that's a particularly serious offense. And then voluntary departure. There are 2 types of voluntary departure. For one of them, they look the other way. They don't consider, if you make their job easy and you just want to leave, they won't look at your criminal history and they'll just let you go. But voluntary departure is considered a form of relief. So if you seek voluntary departure after the conclusion of your case, let's say, no, I want to fight my case, you fight it for 5 years and at the very end, you finally lose. You can still ask for voluntary departure post conclusion of the proceedings. It's a little harder to get. You need to jump through some hoops and make some promises, but they do look at your criminal history. If you have immoral crimes on your record, you can be disqualified. So even for things like voluntary departure, you can be disqualified. Somehow these got duplicated, I apologize. So finally, the how to start mitigating. Sorry to keep talking and rambling on. Very soon, hopefully there's some questions I can start getting into specific subsections. So the first thing you need to know in determining if an offense is is going to be a problem for your client. You need to know what is their status. If they have no status, it will affect how you look at the case. If they are non-immigrant, this one's quick and easy. If they're here on a non-immigrant visa legally, so they're here as a tourist, they're here as a guest worker, they're here as an investor, or anything where they say I have like an alphabet soup visa, like A, B, there's all kinds. Any conviction is dangerous, because these visas, these non-immigrant visas, are completely discretionary, and it's up to the sole determination of DHS and the State Department. So even traffic tickets, if they felt like it, they can revoke their visa. I mean, they don't even need a reason. Non-immigrant visas can be revoked anytime, so you're always on thin ice. So the best advice I can give you, if you have somebody that's here legally on a non-immigrant visa, is to just reduce it as much as possible, make it as innocuous as possible, try to make it what we call a regulatory offense. So traffic tickets are regulatory offenses, things that don't require you to lie, cheat, steal, cause anybody harm. And there's just really nothing we can tell you on these. Anything is dangerous. But for the rest, it really makes a difference whether they are a permanent resident or they have no status at all. So if they have no status, then the next question I would want to know is, do they have any prior deportations? Because if they do, then you're immediately just thinking long-term, what can I do to prevent this person from ever being able to return? And then you're looking at permanent bars to admission, drugs, murder, rape, controlled substance offenses. Same thing. If they already have convictions for possession of meth, cocaine, anything on the federal schedule, they're kind of already toast. And then your only job is to try to keep them out of jail, keep them under the radar for as long as possible. Eventually, ICE will probably catch up with them. So you don't need to stress out too much if they have a controlled substance offense, because once they're caught, they can be removed and they're probably never coming back. So, and then you want to know how many years they've been in the US. If it's less than 10 years, automatically, you know, they're not going to have any short-term relief, but you still want to just try to avoid aggravated felonies and CIMTs, obviously. Do they have any relatives? Same thing. This is just to determine, will they have immediate relief soon or not? Or are we just looking 10 years down the road? And then for LPRs, always you want to find out how many years they've been living in the US continuously, and then how many years they've had a green card. And then you can start looking at 212 and 237. Another big, it's a huge thing among immigration attorneys. I don't know if all you practitioners are going to be able to keep this in mind, but it makes a difference whether somebody entered the United States with a green card, meaning as an immigrant on an immigrant visa, where they had to go to a US consulate outside the US, they were inspected and then admitted at the border in immigrant status. That is essentially the same as a green card, but they don't have a green card yet. They're admitted on immigrant visa, and once in the US, they're given a green card. If you have a person who did that, they will be ineligible for what we call 212H relief. Under INA, section 212, subsection H, that is what tells us who can get certain criminal bars waived. These people will not be able to ask for waivers. If they are deportable, they're either going to lose their green card and be deported, or they need to readjust their status through a family petition or some other means. Most likely it's family petition. Employment-based petitions are never going to get you over these criminal bars. The law only permits waivers for criminal bars where you can show extreme hardship, at least extreme hardship, to a permanent resident, to permanent resident children, spouse, or parents. And sometimes it's adult children, sometimes only minor children. So that's always my first step when somebody calls me up and says, hey, this is what I got. Well, what status do they have? Because I need to know which one of these am I looking at. Am I looking for avoiding deportation proceedings altogether, or am I just looking at mitigation and preservation of eligibility?
Carlos,
Yes.
We have a question.
Okay.
Sean Conde would like to know what info regarding the client and their status would be helpful to have from defense attorneys before conducting a consult.
Okay, so yeah, basically the stuff on this list. How long have they always want to know how long they've been in the country in any of these? Well, non-immigrant is kind of exempted from this analysis because, like I said, they're already on thin ice. But how long have they been physically present in the U.S.? What family relatives do they have? And it has to be, we only really care about spouses, parents, and children, either minor or adult, that are residents or citizens. That's very important. Then I need to know other criminal history to see if they're on the bubble or they can afford to take a CIMT on the record rather than go to trial and get it anyway. And then you want to know this, like, do they have these controlled substance offenses? Do they already have a permanently barring conviction on their record? Finally, do they have any prior deportations? For people who have both drug trafficking offenses or drug possession or aggravated felony offenses who have been deported and who are here again, they are also in danger of being picked up by the U.S. Marshals or by ICE and then the U.S. Marshals and placed in those federal, charged with federal reentry under Section 1325. So that's always something to make clients aware of. Look, we can fight this, but just so you know, you might get on their radar and you're in hot water already. So I think our best strategy is to avoid detection, stay under the radar and not make a big stink. So then after you find out who the person is, what their status is, what their background is, then we look at 212 and 237. Also, I don't know if this is a consideration, but it'll kind of go along with this. In order to be eligible for an immigration bond under Section 236, it specifically says you can't have an offense under 237. And there's the debate. This is one of the examples I'm telling you. I don't remember right now if it also says 212 or not. I think it's only 237. So you ask yourself these questions. Have they already been convicted of other serious offenses previously? And then have they been deported? This is kind of just regurgitating what I just told you. So really quickly, let me look at 237. So first, just so you guys know, this is where I go for mine. I Google INA and it'll take, and the primary source is that USCIS.gov as a Nationality Act. The definitions and where the aggravated felonies are, I'm sorry, let me maximize this, are under INA 101 or also known as 1101 under US Code. So you can go in there. Then 237 and 212 are under the second tab. And I already have that pulled up. So here are there are many grounds of inadmissibility that have nothing to do with crime, but for our purposes, we go to crime. So I'm sure many of you have already read this. Except for blah, 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 any alien who admits committing acts which constitute the essential elements of a crime involving moral turpitude or a conspiracy to commit or a violation of, and then it specifically says a law anywhere in the world to a controlled substance as defined by Section 802, so the federal schedule, not anyone else's schedule, is inadmissible. So if you notice two things right here, they don't say you need a conviction. They say if you admit the essential elements of committing it. So already, it's already really broad. But two, this doesn't, basically any drug offense will get you. So let me give you a quick example. I have an LPR. Oh, actually, I guess I should show you 237 first. Let me show you how this differs from 237. Under 237, they have crimes involving moral turpitude, multiple criminal offenses, aggravated felonies, and then separately on its own thing, controlled substances. So 237 says, any alien who at any time after admission has been convicted of violation of either US code or anywhere in the world, other than a single offense involving possession for one's own use of 30 grams or less of marijuana is deportable. So two things already. It's very similar at the beginning, who has been convicted of a violation, or you admit the elements essentially. But there's an exception here. They actually make an exception for 30 grams or less of marijuana and you will not be deportable. However, if you get 2 convictions for marijuana, you're going to be deportable because you only get 1. And depending on whether you have the time in the US, then you can either seek relief or you're going to lose your green card. And that's how I would game that out. So who is it? Resident. How many years have they been here? 10 years. How many years have they had a green card? 6 years. Great. They will be eligible for relief right off the bat, assuming the crime isn't too bad. So they are residents, they can get cancellation of removal, and they have the time, the physical time necessary. So then this is their first marijuana offense, and we don't know how much, let's say it's more than 30 grams, try to plead it to, you must specify in the factual basis, specify 30 grams. So for immigration attorneys, usually factual bases are your friends. We never skimp these, we never just slough it off, and only when we want to make it super generic will we just list the statute. But these statements are often very key to a case. If you have a resident, it's sometimes beneficial. Sometimes it's beneficial to lock it in as a different drug. Sometimes it's beneficial to leave vague. If the prosecutor you're working with is okay with a legal fiction and they'll do a different substance, great, do that, because you won't burn your one gimme. You'll lock in HU 211, they're not deportable. Immigration will never be able to prove that this person is deportable to an immigration judge. Conversely, if your prosecutor is super straight edge and say, no, I don't do that for immigration clients, fine, will you let me at least not list the substance? Will you let me scrub it from the record? Yes. Will you file an amended information scrubbing the to wit portion of that? Yes. Great. If it's likely that ICE might not even charge this person as being removable because they know they're not going to be able to meet their burden to show that he actually possessed a substance, a specific substance where there's none listed. Now, if I saw this and it's their first offense for 30 grams or less of marijuana or just simple possession of marijuana, I immediately think, oh, there's an exception for that. Great, but it only applies for people that are physically in the US and are residents. This won't help you in other circumstances. So right now you have a gimme, but if it's their second, if it's gonna be their second, you need to really work hard to avoid that second one. Now here's a little scenario I was gonna give you. Let's say I have an LPR, a resident, who gets this offense and you say, okay, great. Carlos told me that he's not going to be deportable. There's a gimme for single offense of possession of marijuana, no problem. Then your client travels internationally and they go back to their home country on vacation, they go wherever. On the way back, they are going to be subject to Section 212 because they are now considered to seek admission into the US. Here's the most aggravating thing about immigration law. It's very tricky. The law actually says permanent residents are not considered to seek admission every time they leave and come back into the country, unless they have certain convictions or have done anything to make them inadmissible. So it's like it's a very big non-promise there that they're making. So as long as you've done nothing wrong, then you're not seeking admission. But if you have a certain conviction on your record, you are subject to grounds of admission, inadmissibility. So the same LPR who I told you is safe from deportation, they're great, they're never going to have to worry about getting deported in immigration court. They leave on vacation and they come back, the ICE officer is going to see, wait a minute, you have a conviction for marijuana in Utah. Guess what? INA 212 doesn't make that same exception for 30 grams or less of marijuana. And so they could still find you inadmissible and you could have to make a trip to immigration court and then seek a waiver. So this is kind of what I'm telling you. It's very tricky to kind of keep all these things. Even though there are two sets of laws, you always got to look out for both. Let me see here, exceptions. Another big area that you want to avoid, another kind of consideration is what's their criminal history look like? Under 212, there are these, like I think I mentioned this earlier, the crime was committed, excuse me, multiple criminal offenses. Any alien convicted of 2 or more offenses, regardless of whether the conviction was in a single trial or whether a single offense arose from a single scheme of misconduct, whether they involved moral turpitude or not, for which the aggregate sentences to confinement were 5 years or more, is inadmissible. Now, looking over this, I've done the research. They only care about the potential sentence. So your client doesn't actually need it to have been spent 5 years in jail. It's enough if they have been ordered or sentenced to 5 years or more. That will trigger this bar. And even if, like, let's say you have 2 DUIs, Class B, and then they have a third. So now it's a felony. So before, they weren't removable under this section because it wasn't possible for them to be sentenced to 5 years yet. Now with a felony 3 DUI, even though it's just purely based on enhancement, they will be subject to this ground. And in fact, I have had a client who this happened to. And normally you would think, this is a DUI. No way this can bar them for life. Unfortunately, because of this clause, because he was inadmissible under this clause, and he needed a waiver, and the waiver says violent or dangerous offenses have a higher standard in order to get them waived. The judge wanted me to prove that DUI was not a violent or dangerous offense. And it was really hard to do when the factual basis was driving a motorcycle and getting ejected and crashing through another window, that wasn't violent or dangerous. And that's a scenario that it's very difficult to get out of. So if they have multiple criminal offenses for which 5 or more years could have been imposed, even if it was all suspended, get some help. Talk to us about that. So, I mean, I am hoping that by doing this, I'm kind of showing you how I do it, how I analyze this. You got to first figure out which category you're in, EWE or resident. Then you got to figure out the history. Depending on which one, what are they going to be eligible for? And then you look at the crime. Okay, what's going to apply? 212, 237. So I wanted to go over some common offenses. Let's see, I have about 15 minutes left, and I hope I didn't put this off too long, but let me get this and I'll answer these 2 questions that I got. So DUI with controlled substance. Always, always, always try to see if you can do a legal fiction to alcohol. Alcohol is always preferable. Theoretical case, your person is a permanent resident and they will be eligible for some type of relief because they've been a resident for a long time. If they have a conviction for controlled substance, that'll for sure make them deportable because that's what 237 tells us. So what if this person had 0 alcohol in their system and 0 meth, 0 cocaine, 0 whatever you want, but maybe they had some metabolites for DUI? Well, you might have to have them swallow a very bitter pill in order to avoid going to deportation proceedings. In this scenario, I would recommend pleading to a legal fiction of DUI alcohol, even though they were factually innocent of that. They had 0% alcohol. If you try to fight this, the prosecutors say, okay, you're right, I'll charge them with DUI metabolite. That's going to be more problematic for your client than if you just swallow that pill and take alcohol. So I would take alcohol every damn time if it's an option. If it's not an option, then try to get the legal fiction to HU211 or phenethentanil. You can look up phenethentanil. I believe it's a Schedule 1. I'm not sure. I haven't seen it in a long time. I rarely use it. I try to use HU211. Whenever I was dealing with a felony, I would try to use benzofentanyl, but again, that's off the table. Quick note on that. This is not retroactive. So the fact that it got put on the schedule a few months ago does not screw up all the cases in the past few years where I pled somebody to benzofentanyl. So it's only whether it's a controlled substance at the time of the offense. That's another good point. You want to look and see if, actually, I guess that's more for an immigration attorney. I don't think you guys are going to be doing that analysis, so I'll just keep quiet about that. So possession of a controlled substance with intent to distribute. Again, I kind of mentioned this earlier. Try to do a legal fiction to the substance, to one of those 2, HU211, phenethentanil, and state in the factual basis there was no monetary remuneration for this. Possession of controlled substance, same idea, except there's no monetary remuneration necessary. For all of these, in order to sweeten the deal, you might want to consider giving them a higher degree of offense in order to lock in a substance that won't harm them. It's preferable. So aggravated assault. This is super super aggravating, all assault DV offenses. So quick thing on this, for a long time, we always said, like, under certain circumstances, DV offenses, DV assault is okay. Mostly DV assault is okay in Utah because it does not actually require physical harm. It can be a threat of force accompanied by, ooh, Chad Utley. Can you type your question, or I don't know if you can unmute you. But while you're doing that, I will note, for a time period, a 10th Circuit decision affected us here in Utah. A federal public defender tried to fight the CSSA for sentencing for somebody. He tried to fight an enhancement. And the 10th Circuit made this awful decision in Betcher. I forget what I think it's Betcher v. whoever, US. They found that recklessly committing an offense was equivalent to intentionally committing an offense for purposes of enhancement purposes for his case. And so the savvy ICE attorney said, great, that means if it's good for them, it's good for us here in immigration land, because we rely on 18 USC 16, this offense right here. It is a crime of violence, an offense that has as an element the use, attempted use, or threatened use of physical force against a person or property of a person is a crime of violence. Subsection B, we fought a few years back, Skylar Anderson did, and he got the 10th Circuit to say that this is void, constitutionally void for vagueness, thank God. So for like 2 years, we could no longer have any DV assaults, any DV, excuse me, geez, I'm blanking out here, breaking another's, I feel very exposed at the moment. I'm trying to think of, I'm sure you're all yelling at the screen right now, but basically damaging the property of another. You couldn't have that because you'd be in hot water with immigration. Luckily, a Supreme Court decision came out a few months ago and basically undid the 10th Circuit's decision. They said, obviously that's stupid. Reckless conduct, it cannot be considered the same as knowing and intentional conduct. So we're back to it being mostly safe, but try to always, in the factual basis, state that there was no physical harm actually done. That's always best to try to specify, or no physical damage, no serious bodily injury, because that's really what gets us in trouble here. Let me see if I can see that question. Thank you. Criminal mischief. I use it every day, and yet when I needed to, I've had to remember a lot of things today, folks. So hopefully I didn't lose all credibility. So for criminal mischief, actually, let me just go in order. I have these. So burglary in Utah's version of burglary can be a deportable offense. It can be an aggravated felony, but it does not necessarily have to be. Let me show you. I think I have it up. Penalties, retail theft, wrongful appropriation, burglary. So if you were to pick theft, assault on a person, sexual battery, actually, so not all of these, but if you were to pick theft, then this could be considered an aggravated felony because it's a felony first and foremost. And then you pick a theft offense, punishable by over a year. So we always suggest doing a felony, because what the hell does that mean? You could theoretically, if by picking a felony, you could say my client unlawfully entered or remained in a building with the intent to possess the identification documents of another, 2 of them, therefore it's a felony and you satisfy the requirement. That can't possibly be linked to the definition of INA 101-43 and under theft offense or anything. So you would be fine in the sense that it's not an aggravated felony. But remember, there's always more to the story. You always think they can get you like 5 different ways. So fine, it's not an aggravated felony. Is it a CAMT? Well, no, because it's not specifically telling me there's moral turpitude involved. I don't have to specify what felony. And again, theoretically, you'll leave me open to argue, well, he could have been wanting to possess IDs. And honestly, they're not going to question us on that. They're not going to have us look into what it was. They just have to take it on its face if it's clear. So It would not be a CIMT, it would not be an ag fel. So then are there any other problems? Well, if they're permanent residents, are they deportable under 237? Let's find out. So it's not obviously not a drug offense. Is it a crime of moral turpitude? No. Is it multiple criminal convictions? Well, that's where that comes into play. So if this is their only offense ever, and it's punishable by up to 0 to 5 years, then they're technically not deportable yet because they don't even have a traffic ticket. So they're not deportable. However, if they do have a traffic ticket, they could trigger this potential ground of removability. But then we have to go into court and find out about it. And actually, sorry, this one does say crimes involving moral turpitude. So I was thinking of 212. See, I get confused. That's why I have to read them, because I always mix them up. Which one requires moral turpitude? Which one says regardless? And 212 says regardless. So then is it an ag fel? No. High-speed flight? None of this stuff. Sex offenders? So honestly, no. They would have a felony on the record, but it doesn't make them deportable in and of itself. However, again, now here they catch you on the other end. If this person leaves the United States and they come in and they do have other offenses, then 212 would come into play. And because they have these offenses, and any alien convicted of 2 or more offenses, regardless of single scheme and regardless of moral turpitude, for which 5 or more years, they can get you that way. So they could be inadmissible and they still end up in removal proceedings. It's kind of absurd, but you only get to this level by doing grueling and practice. So felony theft offense, always avoid theft offenses, obviously. And I know I'm like preaching to the choir here, but these can be aggravated felonies. One of the portions say if the amount exceeds $10,000, any offense to commit, I forgot what it is, but it basically like theft by deception, any fraud case involving 10,000 or more, that's an aggravated felony. So avoid that. For assault, I forgot to say it, and aggravated assault, we're of the opinion in this office that it's probably okay. We can probably defend those DV assaults, but just try to make the factual bases as clean as possible. And if possible, try to use threat of violence. Geez, I'm running out of time here. Sorry. So let me get to these quick questions real fast. So I got this question. Is it always a bad idea to expunge records for non-citizens? I've heard that it recently told me that somebody did advise them if you just get certified copies ahead of time. Mostly it's a bad idea because it just creates problems for the person in the future if they're not citizens, because they're going to you always need to confess all your sins, even if you've expunged them, even if everything. And the biggest problem is you're essentially, the plan in theory, I'm not advocating this, but the plan in theory would be expunge it and then pretend like it doesn't exist, and then it's implied that the person would lie that it never happened. Well, the problem with that is we never know what information the government has already. So if the person's conviction is on any of DHS's databases, it doesn't matter that you erase it from the FBI, it's already on DHS's. So the client is taking a big gamble to get hit with, hey, we know about this, and hey, you lied to us, so we're going to deny you, and now you need another waiver. The other question I got is, what's the best option for resolving marijuana-related possession? I think I covered that already. Always, I would say, try to lock in HU 211, and failing that, paraphernalia in and of itself is okay. We still have to fight about this, but legally under Malooly Supreme Court decision, paraphernalia is okay as long as you don't list which substance was related to that paraphernalia. Try to just stipulate to it's a controlled substance. If it's somebody that is not a permanent resident, remember, they're going to be reviewing our work. They can ask us to see the record and see what it was. So try to lock it in as a substance that's not federally illegal. It's almost always best to lock it in as to a legal fiction, to a non-federally controlled substance, rather than leaving it ambiguous. But if that's not an option for residents, we try to leave it ambiguous. And I believe I'm mostly out of time. I see I have one more question. I hope this is helpful. Oh, a purely political offense is like if you live in Venezuela and you speak out against him and they imprison you for 5 years for that, that's a purely political offense, non-violent, non-drug related, basically non-legitimate. So the slideshow is, I do have some scenarios on here, but like I said, we're out of time, and I thank you so much for your patience in hearing me talk for so long.
Thank you. Thank you so much, Carlos. Really appreciate it. And these slides and a recording of this presentation will be on the IDC website. I know this was a lot of information, so you're welcome to go back and watch it again and look at some of the detail, and hopefully that will help also answer questions.
Please feel free to reach out. We are not, we don't turn our noses up at anybody. We like to help. It helps us do our job on the back end, the immigration portion.
Oh, thank you very much for everybody who was able to stay the whole time until 1:30. And thank you so much, Carlos and Lynn, for all the information you shared with us. Your contact information is on the slide. So if people have questions or need consultation, please feel free to contact Carlos and Lynn. Our next CLE will be on September 17th, and it will be a panel discussion on jury selection. So we hope to see you then. Again, thank you, everybody. Let's see, was there any last moment question? For CLE credit, my understanding is that since we had an opportunity for a Q&A as part of this presentation, that qualifies for the e-verified CLE. So I will submit all of your names to the bar for the 1.5 hours of CLE credit. So I will take care of that at no cost to you. Thank you again, and we hope to see you on September 17th. Bye-bye.
Bye, thank you.